This morning's docket, case number 111006 and 111895, State of Kansas v. Alcala.
May it please the court, Joanna Labastida of the Appellate Defender Office for Manuel Alcala. If I may, I'd like to request 3 minutes rebuttal.
3 minutes is granted.
Thank you. I'd like to focus on the two restitution issues that were in my supplemental brief. The first issue is that the district court erred in determining restitution by ordering attorney's fees related to a sink case and the adoption of Mr. Alcala's children. I apologize. As this court knows, the standard of review involves, this issue involves an interpretation of KSA 216604B1, and this court has unlimited review. The district court's factual findings underlying the causal link between the crime and the victim's loss are subject to a substantial competent evidence standard of review. Excuse me. In this case, there was a sink case involving the two children of the defendant and the victim.
In the sink case, there were competing interests, is that right, in terms of custody of the children?
It appears from the record, yes, that...
it wasn't just the mother of the victim who was seeking custody. There was also, I think, siblings of the defendant who were also seeking custody. Is that right?
At least those.
At least those,
Mm-hmm.
okay.
And I believe there was perhaps one other party that was seeking custody as well. I don't know actually how far any of those interests got in the proceedings. Obviously, the sink record is not a part of this record. But yes, as far as we know, there were at least a few other competing interests.
Okay.
Why isn't, once you get past the sink proceeding and the sink court says it's all right for Mrs. Bacon, the grandmother, to adopt, why wouldn't the adoption proceedings be necessarily flow from the crime? Once you're at that stage, because we don't have a mother and father's going away, and so the kids needed to be taken. That situation results from the crime, it seems to me. So I understand when there's competing interests in the sink case, but I'm having trouble seeing once that gets resolved, why this doesn't link back to the crime.
I guess my argument would be that the causal link between the crime and the sink and the adoption case was the hiring of a private attorney. In the sink case, or in sink cases, you're perhaps entitled to appointed
I don't care
counsel.
about the sink case. I care about the adoption.
I'm not sure exactly what the process is for adoptions, if you even need an attorney to help you with that, or if that's something that you can do on your own. Honestly, I'm not experienced enough in that field to...
So your defense against that is that somehow it's an unreasonable expense as opposed to something that flows as a natural consequence of the crime.
I would say that it's tangentially related.
A luxury rather than a necessity.
Okay. I will concede that the motion filed by the defense attorney did specifically relate to the sink case, and that a lot of our argument is related to the sink case, and that was a substantial amount of the attorney's fees that were issued. So if this court believes that the adoption fees are related, our focus is more on the sink aspect of it, because it was $18,000, a little over. As was cited in the motion below, and in our case, or in our brief, there is a possibility of appointed counsel in sink cases, and it appears the grandmother did not know that, so she went out and hired an attorney herself. And we would argue that that is the interruption in the causal link between the mother's death and, Mr. Alcala's crime and the related costs.
What are the conditions for being able to get appointed counsel in a sink case?
I believe you have to be an interested party under KSA 382241D, which, if you look at that statute, requires that the children had been placed with that interested party for let me see, I want to get the wording right. Of any person with whom the child has resided for a significant period of time within 6 months of the date the child is in need of care petition is filed. And the argument below is that that's not restrictive as to the timing of before the petition or after the petition. It just says within the date. And so the children were placed with the grandmother almost immediately after the death of their mother. And at some point she could have requested appointed counsel. It just says if the party is financially unable to employ an attorney, the court may appoint an attorney for the interested party.
So the trigger is financial inability.
Right. There was some testimony at the restitution hearing that her yearly income was $20,000. So I would assume that she would qualify for some sort of appointed counsel with that income.
I guess you can assume that, but where is it in the record that she would have qualified for assistance
Well, she
had she
didn't.
not hired an attorney?
She didn't apply for that. She didn't know that she was that was available to her. So we don't have any evidence that was even attempted.
Then how can we assume it on appeal?
I guess just with the low income that was stated, a yearly low income and no other income coming in besides her Social Security.
Would you have waived that argument? Because I understood what happened was that no one was challenging the reasonableness of the fees, and it would seem to me that that is an issue of reasonableness. I mean, in a typical awarding of attorney's fees kind of thing, that would seem to be an issue under that notion as opposed to just whether the causal connection gets you to
There started to the defense attorney started to elicit some testimony about what her assets, the grandmother's assets, and why she chose to go with this attorney, I suppose. But she didn't get very far in her questioning. And in her motion, she did discuss that that it appears the attorney's support staff came with him to a lot of the hearings, and they charged for that as well. But there was no argument at the restitution hearing about the actual unreasonableness of the fees, and unfortunately I didn't have enough in the record to challenge that. I did, however, raise issue 2 in the supplemental brief, which is that the restitution amount generally is just unworkable for a defendant who is incarcerated for essentially the rest of his life if he is not given parole at after 25 years.
Was there testimony or any evidence before the court that the defendant did not have at that time assets available for restitution?
He did have a small amount of assets that were applied. That was applied to the restitution amount, a little over $5,000, I believe. And so, in as much as that was evidence that he had some assets.
So the court was able to have evidence of what he had at that time.
Yes.
And then the court also knew that he was being sent to prison for, was it a hard 25?
Yes.
For a hard 25.
Mm-hmm.
Okay.
And
If we, circling back to your other argument, if we can't determine that the grandmother would have been eligible for an attorney, where does that leave us with your argument? Is your argument dependent upon the possibility that she would have had an appointed counsel?
it's heavily dependent on that because it does seem reasonable for her to want professional counsel at the sync hearing, and especially if there are other interested parties. Perhaps if it was just her that had custody of the children, and then ultimately that seems like where they would be replaced, maybe it would be less necessary for her to hire an attorney. So I struggle to.
But would that appointed counsel be paid?
I'm assuming through the state.
So there would be attorney fees accrued because of this, and so we're just talking about who the payee is, whether it's her to pay her private attorney or the county to pay the appointed attorney, but the attorney fees would still, you're not disputing that attorney fees were necessary, it's just to whom and how much.
Yes.
Which is different than I understood that you were saying, that there shouldn't have been any pay.
In my brief, I did focus more on the fact that it was her choice to hire an attorney. But in preparing for the argument, and reading the transcripts and kind of thinking about it, yeah, any layperson would probably feel more comfortable going into that situation with an attorney. And that's why I am focusing more on the fact that she could have sought appointed counsel.
So your remedy is to remand to do the factual findings of what it would have been if it had been appointed counsel, or?
Yes.
Or do we have a problem? Was it your burden to make sure that we had a sufficient record to know these things at this point? Defense below's burden to have made a record.
That would have been helpful on my argument, but unfortunately I'm working with what I have here, and the statutes kind of give us some guidance as to who would be eligible for appointed counsel. The attorney did elicit her income and other assets, so I think those two things in conjunction, this court could make that determination.
Any further presentation?
No, Your Honor.
Any more
I just
questions?
want to make clear that, I'm sorry, Chief, I guess I just want to make clear, as it pertains then to the Sink case, you're not making an argument that the grandmother needed to have an attorney and that need relates back to the fact that your client committed the crime, that there is the causal connection between the crime and the need for the attorney. You're now just whether it should have been public defender type or a private counsel.
Well, I'd like to argue that that causal link was interrupted by her decision to hire private counsel, and that therefore kind of erases his responsibility for paying for that attorney.
But I'm just trying to make the link between the killing and the need to have an attorney at the Sink proceeding, not worrying about who the attorney is at this point. You're not saying that there isn't that causal link between the crime and the Sink proceeding.
Well, frankly, I think that the need for an attorney is related more to the other parties that are injecting themselves in the Sink case, not necessarily the fact that there is a Sink case. Because if it had just been the grandmother who the children were immediately placed with, she probably wouldn't have needed an attorney.
So you are making the argument. I'm
Yes.
just trying to figure out what our issues are here, and I understood you to give away the causal connection point because in response to Justice Johnson's question, what you wanted was a remand to determine the difference between private counsel and appointed counsel.
If this court believes that causal link was interrupted by her hiring private counsel and that was because of the other people that were involved in the Sink case, then I am all for this court just vacating that restitution amount. But if I'm going to split the baby here, I will argue that this should be remanded back for that determination between the appointed counsel and the private counsel.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, again, Assistant District Attorney Jody Litfin, appearing on behalf of the state here. I'm just going to keep it short in saying I believe that the causal link is here, but for the homicide, we wouldn't have the Sink case. But for the Sink case, she wouldn't be an interested party and need counsel. So that's the simplest way I can put it.
But is it true that when the Sink case was instituted, that grandmother was the first placement for the child? So she had the child or children in her care.
Yes.
And it seems to me the but for is that you had defendant's relatives and others that wanted to challenge the grandmother's custody of these children. And what necessitated the need for an attorney in the Sink proceeding was the challenge to her custody rather than the fact that a Sink
That there was
it
one.
needed to occur. Where am I going wrong there?
I would disagree with that. I think she could have had counsel whether if she was the only interested party.
She could have, but
And I
did
think
she
she has
need
a right to it.
Well, but if she basically had won immediately and had custody of the child, and you have caseworkers that are working on there, and one thing and another, would she really have needed? It's not a but for if it's a luxury, is it?
No,
Yeah.
I'll agree with you there, but I don't think it's a luxury here. But I understand there wouldn't be $18,000 worth of attorney's fees
Yeah.
if it wasn't contested. My main point is there is the causal link between the crime and the Sink case here.
But it's not the Sink case. I guess you need to
It's the
convince me
contest-
that it's the Sink case that is the trigger as opposed to the challenge to custody. Because it seems to me, once you get the challenge to custody, as Justice Johnson's saying, that's why everybody lawyers up in these cases and then decides to have a fight. And so it just seems like that's got to be the answer. So why isn't it? I mean, you're here to argue that it isn't, so why isn't it?
Correct. Well, I mean, I think in my brief I didn't focus on that portion of it. I guess to me, still, it's the Sink case. It's the initiating of the case. I think
Counsel,
that triggers it.
how common or uncommon an occurrence is it in a Sink case for there to be a contested custody between various relatives?
I believe it's common.
So, do you think that's foreseeable, a foreseeable consequence of a Sink hearing?
I do. Yes. And as far as the unworkable argument, I would go with our position in the brief that there was no evidence presented and that the defendant didn't meet his burden to show that it wasn't unworkable.
Do you disagree that the court had information about defendants' assets at that time when they, and some of those assets were applied?
No, I don't disagree with that. I don't understand really how that got there, but the court mentioned someone is here, and they mentioned a $4,000 number about assets, and it was
Well,
kind of a sidebar, but I
guess,
agree.
I guess the court knew that there were no more assets for this defendant to pay restitution right now.
Yes.
And the court knew that this defendant was gonna go to prison for 25 years.
They had judicial notice of his sentence, yes.
And the way I read the statute, it talks about compelling circumstances which would render a plan of restitution unworkable, unquote. So if you have no money and you're going to prison for 25 years at a minimum, why isn't that compelling circumstances that would make a plan of restitution unworkable, that requires no more proof from the defendant? The court's aware of the compelling circumstances.
Well, I don't know if just because the court was on judicial notice and then had that information, I think the defense counsel still had to present some evidence. And they cited to the website here about how much he made every day in prison. So, I mean, that evidence, I think, at least goes towards the fact that he is making some money. And whether he can pay it all off at the end of his sentence or not, that doesn't make it unworkable. He still has an income. So I think that helps our case, even what they raised on appeal, which they didn't raise below in that. I don't think I have any other presentation. I would just ask that this court affirm the restitution order in this case.
Any more questions? Thank you, counsel.
Thank you.
At this point, I'm prepared to waive rebuttal.
I'd like to hear you respond to the foreseeability issue, that if it's commonplace for a Sink case to generate competing interest wanting to have custody, then how can that be a efficient intervening cause?
I think in typical circumstances, that might be something that could complicate the issue. But in his circumstance, you have the defendant and various other relatives that were involved in her murder. And then you have someone who, and the brother of the defendant coming forward to try and get custody of the children, which I think maybe the family's reputation might overshadow that as proper placement. And then you have a non-relative coming forward to try to receive custody. So I think the grandmother was, even though there were other competing parties, she was the obvious choice for placement as far as the custody of the children. And so even though those parties were involved, I'm not sure that she necessarily would have needed counsel to be the obvious choice.
The question is for this defendant to effectively orphan his children for at least 25 years, why wouldn't it have been foreseeable that there would be a custody fight? And if it was foreseeable, then why is the custody fight a intervening cause that cuts off but for his action?
I'm not sure that it is foreseeable that there would be a custody fight, especially with the grandmother being really the closest relative that's available and proper for placement. I don't think that is foreseeable automatically.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. Now